My name's Mark Doran. I represent landowners in regulatory and surface rights matters in the province of Alberta. Mr. Bill Heidecker, who is the president of the Alberta Surface Rights Federation, that's the overriding group that represents a number of other surface rights groups within the province of Alberta, suggested or requested that I make this video. So here goes. The topic of the video, as I share my screen, is there's really two topics. So terminating a surface lease agreement for default. And the second topic I'm going to go through after that is there's a lot of questions out there about when landowners can deny entry to a oil and gas site, particularly because the operator hasn't paid. And so there are some entry denial do's and don'ts, and I'm going to go over those as well. Just to sort of round out this video. I'm going to hopefully keep it under about 30 minutes or so. So let's go. Overview, what one needs to know. 3 or 4 or 5 things, we'll go over them. First of all, in addition to a license, permit, or other approval, what's called a surface right of entry in Alberta is required in the event that the licensee of the activity does not own the land or the surface rights, to be more accurate, for the land where the activity is proposed. This can be for any activity that is listed in Section 12, subsection 1 of the Surface Rights Act. The activities for which one requires this, what's called a right of entry, and for which one can force their way onto the land, which I'm going to get into under item 2 here, are removal of minerals. That could be a coal mine, a well, gas well, oil well, or an injection well. It can be a pipeline. It can be tanks, stations, and structures associated with that removal of minerals. I should have said that before. A pipeline. It could be for a power transmission line. That includes a power line or a substation, and it includes a telephone line, but that's rare and becoming even more rare with the advent of cell phone towers, etc. So there are 2 ways to acquire this, what's called a right of entry, what's required by law in Alberta. The first is pursuant to a private agreement, defined as a surface lease in the various laws we're going to look at. And this would be an agreement between what's called operator, that's a defined term as well, and the landowner or occupant of the land, someone who might rent the land for farming or other purposes. That's the first way. And then in the event that the surface owner or occupant refuses to sign an agreement offered to them by the operator, the second way to get on the land is called a right of entry order. That's a forced taking of land rights issued by the Land and Property Rights Tribunal. Those right of entry orders can only be issued for the activities I mentioned: wells, mines, or removal of minerals and tank stations and structures associated with them, power lines, pipelines. And so this does not apply to solar farming, does not apply to wind farming, it does not apply to gravel pits, and numerous other activities. One can say no, and that's the end of it for solar farm, wind farmed, any activity that's not listed in Section 12(1) of the Surface Rights Act. If the landowner says no for a Surface Rights Act activity, then the holder of the license or the person who wants to conduct a license exempt activity can go to the Land and Property Rights Tribunal, apply for a right of entry order, and almost certainly, unless something's out of order, almost certainly that right of entry order will be issued. A few more things that one needs to know. An agreement granting this right of entry we just discussed is called a surface lease agreement. I already said that, but I want to stress that. For most surface lease agreements have a term. In fact, common law principles that have been stated by the courts in Alberta have stated that if a lease agreement does not have a term, it's invalid. So the stated terms are usually 20 or 25 years. I've seen some with 10. So one's got to check you've got to check your own agreement. But the key here, the key to remember is almost all of these agreements, if not all of them, have a provision whereby the term, whatever it might be, automatically renews over and over. So it says at the end of the term, the 25 years, for example, you automatically enter a new term for the same period of time, provided the operator is not in default of the terms and conditions of the agreement. So under the same contract common law, any agreement can be terminated for default or for cause. So now termination should not be confused with the term surrender of a surface lease that we're going to get into, and that's under the Environmental Protection Enhancement Act, and it has to do with reclamation certificates. So surrender of a surface lease, that's what we're going to talk about for a while. This is where there's a myth out there that because of this requirement that's on operators to get a reclamation certificate so that the surrender of a lease is binding on the landowners, this is conflated with some sort of an idea that's mistaken that the landowner can't terminate the lease because the operator has to get a reclamation certificate. That's simply not true. You certainly can terminate a lease for any sort of a default, okay? And I'm going to get into how you do that. So land that is defined, what's specified land as defined in the Environmental Protection Enhancement Act, or the EPEA for short. Some people call it EPEA, EPEA, must be conserved, reclaimed, and certified as reclaimed. That's the law. We're going to take a look at the actual provisions of the law that require this. And no surrender of a surface lease. Now, this means surrender means, surrender means getting out of a lease before the end of its term. That's what surrender means, okay? So no surrender of a surface lease is binding on the owner of the land insofar as it pertains to specified land until a reclamation certificate has been issued, and we'll get into that law. So this is it. Section 141A under Part 6 of the Environmental Protection and Enhancement Act reads as I've quoted it here. So the title of this section is No Surrender or Termination Without a Reclamation Certificate. The word surrender pertains to surface leases. The word termination pertains to right of entry orders. That's as per section A and B, subsection A and B in this particular provision that we're going to read. So it says, notwithstanding anything in any other act, so in spite of anything in any law, or in spite of anything in any surface lease or right of entry order, these two provisions apply. So this is the governing, this is the granddaddy provision. It prevails over everything else, including your lease. It says no surrender of a surface lease is effective or binding on any person, and then we'll skip over B because we're really talking about termination of surface leases here. So no surrender of a surface lease is effective or binding on any person insofar as the surrender or termination relates to any interest of the registered owner, that means your surface rights, until a reclamation certificate has been issued in respect of the specified land affected by the surrender or termination. Simply put, if your land is specified land and the operator tries to surrender the surface lease and he hasn't gotten a reclamation certificate, that he cannot end that surface lease with you. So this provision pertains to him only. It does not pertain to anyone as a surface rights owner. So as I stated on the bottom, nothing in the law prohibits termination of a right of entry without a reclamation certificate for cause. So for, or because of a default, and that's what we're going to talk about. So this just protects landowners that when they want to give the land back to you, let's say the lease is over, I don't want to pay you anymore, they got to give you back clean land. That's all it means. It shouldn't be interpreted to mean that you can't terminate the lease for default. Okay. Now, briefly, let's go up and look at 141 subsection B. It says no expropriation board, excuse me. That means the Land and Property Rights Tribunal or any other expropriation board shall order the termination of a right of entry order until there's a reclamation certificate. So right of entry orders, they have no term. They're all indefinite. So the term surrender can't apply to it because the operator has to go to the former Surface Rights Board, now called the Land and Property Rights Tribunal, and request a termination. And to do so, if they've used the land, if the land is specified land, then they must produce a reclamation certificate. Otherwise, the Land and Property Rights Tribunal lacks the necessary jurisdiction or powers granted to them by law to terminate that right of entry order. So that's why that's in there. And that's why the term termination and surrender are different, because the procedure to get the operator would actually have to apply for termination of a right of entry order. And that's why the word termination is used differently than the term surrender, because we're talking about something different. So that pretty much covers that. What is specified land? I'm going to just try to go over this as briefly as possible. So there's a definition in section 134, subsection F of the Environmental Protection Enhancement Act, and I've quoted it here. So it just means specified land means something, and there's another definition in the regulations, and that's why I've underlined within the meaning of the regulations. It means specified land on or in respect of which an activity is or has been carried on, but does not include the following things. So there's certain exemptions to do with residential land, etc., that don't apply to the vast majority of agricultural lands out there. In particular, subsection 2 doesn't apply because 1 doesn't apply. It mentions agricultural purposes, but if there's an oil and gas well or a facility on your land, then it's not being used solely for the purposes of agriculture. It's been used also for oil and gas. So that means there's no exemption here. And crown land this doesn't apply to crown land. So that's part of what the definition of specified land entails. What you really need to know in the Act, that there are a few exemptions, okay, mainly residential land. But there's also another definition in the Conservation and Reclamation Regulations, which is the regulation they're referring to in the Act. And it says that specified land means land that is being used or held in conjunction with, and they list a whole bunch of things, and right at the top of the list is wells, pipelines, or batteries, or oil production sites. So that means all surface rights activities on people's land. That further down it does talk about telecommunication systems or transmission lines. So all surface rights activities create specified land, but it says that land is being used or held. So that means used or held legally pursuant to a right of entry order or a surface lease, or some people call surface leases, if they're for pipelines, right-of-way agreements, doesn't matter. Surface leases all encompassing means all agreements, including right-of-way agreements for pipelines and power lines. And or if they trespass, so if they go off their site or they are using land without getting the necessary right of entry order or the necessary agreement, this does happen. Trespasses, that's called trespass under Section 38 of the Service Rights Act. And trespass is a heck of a lot more common in oil and gas than people realize. In fact, it's really, really, really common. Landowners don't realize how much trespass is occurring on their lands, or the massive damages that are potentially recoverable from operators for using your land contrary to the terms of the Service Rights Act. So that's what specified land means. So there is this duty to reclaim set out in Section 137 of the Environmental Protection Enhancement Act, and I've quoted it here, and it simply says an operator must, this means there's no choice, it's mandatory, must conserve specified land, reclaim specified land, and unless exempted by the regulations, obtain a reclamation certificate in respect of the conservation and reclamation. So unless you're exempt under the act or the regulations, the operator has to get a reclamation certificate. So now, if they haven't used the land, they've conserved it, and the application would be quick and easy, and probably they would speedily be able to get a reclamation certificate, but they've still got to do so in almost all cases, okay? Even if they really haven't used it. And in fact, I did argue what was specified land in a hearing myself, proceeding 411 of the Alberta Energy Regulator. I had a road on client's land that was acquired, a second road into a well site. It was surveyed. There was an agreement for that road, but they never used that road. And both the landowners and the operator agreed that operator never set foot on that road even once, only to survey it. The AR found that that road required a reclamation certificate. So that's that's quite enlightening for cases where a well site agreement's been acquired and then maybe not been used, and the operator pays it for a few years and then stops paying. You can potentially recover retroactive payments until that reclamation certificate has been issued, even if they didn't really use that land, as long as there's been an agreement signed, according indicated by this proceeding ID 411 decision of the Alberta Energy Regulator. So that's the duty to reclaim. So let's get into default clauses. So most surface lease agreements contain a default clause. And I've given two examples here. The top one is in almost every lease I've ever seen, or a variation of it with the same meaning and implications. And the bottom one I've seen has added words that I've seen in quite a few cases. The bottom one was really, 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 I don't know why any landowner would ever agree to this. So most surface leases have another clause that say that any notices have to be given in writing. So you must give a written notice, not a verbal notice. I can't stress this strong enough. A written notice, because of this default clause. So read your lease. Chances are your lease will contain a default clause like this. And I'll read the top one. It says, notwithstanding, which means in spite of. So in spite of anything herein contained to the contrary, the lessee, that's the operator, that's the oil company, shall not be in default of the performance of any of its covenants or obligations under this lease agreement, including the payment of compensation, unless and until the lessor, that's the landowner, has notified the lessee, that's the operator, of such default. And the lessee, that's the operator, has failed to commence action to remedy the same within 30 days of receipt of such, and we should add in here, such written notice. So translated, simplified, what does this mean? Even if he doesn't pay you, and for any other default, including payment, the operator's not really in default. You've agreed that the operator's not in default until you give him notice of that default. So you have to give him notice. So I'll come to what that notice should say. So let's go down to the second one. I want to read the last paragraph right here. Sorry, the last sentence that's added after the paragraph, because the first sentence is the same. So it says, for the purpose of this clause, a letter by the lessee of its intent to remedy a default shall constitute commencement of action to remedy the said default. So in other words, they don't necessarily have to pay you. All they have to do is promise to pay you. If the default is, well, hey, the agreement says they have to repair fences around their lease and they haven't been doing it, well, you can terminate the lease for default of that too. Or I mean, it could be many different things depending on what they've agreed to do in the lease. As long as they're in default of an agreement or a covenant or an obligation in the lease, you can terminate that lease. So and non-payment's only one of those possibilities. Okay, but what this last sentence down here that may not be in your lease, but is in some leases. I've seen this in Encana and in the company that took over in Canada's shallow gas wells, what they call coal bed methane wells. That's Ember Resources. This is where I've seen this sentence the most. So that sentence says that all they have to do is promise to pay you, and then they could they could probably delay the termination of their lease for cause. But I would say they'd still have to pay you within some reasonable period of time. But that's getting into gray areas. So bottom line is, if the lease you're being proposed to you contains this last sentence, my suggestion is just don't sign it. Make them get a right of entry order if they won't agree to take that clause out. So because of these default clauses in lease agreements, you've got to give written notice. If you want to terminate the lease, you've got to give the written notice first, and you've got to give them the time, 30 days, to cure that lease. And if they don't cure the default in 30 days, well, then the lease, you can say the lease is terminated. And here's how we go about doing that. You need to give written notice to the operator of his default. I'm going to try to explain how to do so. It's hard to give exact wording because the different circumstances that anyone might want to rely on to terminate a service lease can be different. So, for example, you definitely want to say, take notice that you are in default of the terms of the subject surface lease agreement. Give its date, give its land location. If you know the well license number, you can find that through the Alberta Energy Regulator's one-stop public map viewer. Give the well license number, the facility license number. Give as many details as you can so that you're identifying this particular surface lease. But definitely give that surface lease's date, and then give the details of the default. So if the default is non-payment, say you are obliged to pay, for example, $3,500 per year, and you haven't paid for X years, and therefore, for example, it was 2 years, you'd say, please pay $7,000. There could be many other reasons for default, depending on the terms and conditions of your surface lease. So read it. For example, if the operator is obliged to fix fences and he's failed to do so, tell him that he's in default of his obligation to fix the fence, and say you must take notice that pursuant to clause X of the lease, you are required to fix the fence, but you're not doing so, and therefore you're in default. So state the nature of the default, and then tell them, as I've said on the bottom, say, take further notice, and bold these words, make sure they know that it's a notice, that unless the default, whatever it is, I've used the example of non-payment here. Would be probably the most common these days, unfortunately, for landowners. Unless you've cured the default and give them 30 days or whatever time period might be specified in your agreement, it's usually 30 days. Then unless the default's cured, unless you've received payment in full, unless they fix their fence, etc., within 30 days, that the surface lease shall automatically terminate without further notice to you. And that's very important, without further notice to you. Now, what I'm going to discuss next is that you may want to add something else in to your notice, that depending on, particularly if it's a well, that might incent this operator to pay. So I have given these notices and talked about what I'm going to talk about next to many operators who weren't paying. And in all but one case, they immediately paid the landowner. You don't necessarily have to file an application under 36 of the Service Rights Act to try to get paid. This is probably much faster and might be much more effective. So even if they cure the default, you've gotten your payment. So even if they fix the fence, at least you've gotten your fence fixed, etc. So anyway, if the lease terminates, this triggers further obligations of the operator, which could be very expensive for them. So that's what I'm going to deal with next. So I'm just going to pause, and I'm going to bring up the related law. The related law is the Oil and Gas Conservation Rules, Alta Reg 151/1971. And I'm going to show the table of contents here. We're looking for under section 3 or part 3, um, section 3.012. So we'll just scroll down and we'll find it right here, and it's entitled Abandoned Wells. So if the lease is for a well or a facility, okay, because it says here, a licensee shall abandon a well or facility on the termination of the surface lease or right of entry. So shall is a mandatory term. In other words, the operator has no choice. And if you go to the Alberta Energy Regulator and say, my surface lease has terminated, they no longer have a right of entry. He's now trespassing. You must order this operator to abandon their well. And they have to do it. And if they don't do it, you can take it to the appeal court, and the appeal court will, without question, order abandonment of that well. So if you like, you can put that in the notice. Be careful not to threaten. Just say you may be required to abandon your well. You may be forced, the AR may require you to abandon the well. You should be aware of that, something to that effect. That's up to you. Get a lawyer to do it. Call a professional, a land agent, somebody like me to do it for you if you're concerned. But you can state that this could trigger the obligation to abandon the well. That means they can't produce the well anymore. So if it's still producing, well, you can probably get your payment. This is what I'm trying to tell you. So that you should be aware of as something else you might want to include in a notice of default. So to sum up on how to give notice of default and how to terminate a lease, that's how you do it. You may or may not want to add in the abandonment clause, but remember that if they do cure that default within the 30 days or whatever time period you give them, then, the lease is not terminated. You have not terminated that lease. So just be aware of that. So that wraps up the first part. Let's get into the second part of the video. I'm going to do it by looking at a couple different laws, and we're going to talk about for what purposes you can legally lock an operator off the land if he hasn't paid or is in default of his lease, and you have actually terminated that right of entry under a surface lease. We'll talk about that next. So let's look briefly at the laws. Other than we've already looked at the Environmental Protection Enhancement Act. Let's look quickly at the Service Rights Act, and let's look at section 12, right of entry, which I talked about. And it says no operator has a right of entry in the respect of the surface of any land for these things until the operator has obtained the consent of the owner and the occupant of the surface of the land, or has become entitled to right of entry by reason of an order. That's a right of entry order of the tribunal. That means the Land and Property Rights Tribunal, the former Surface Rights Board, under or pursuant to this Surface Rights Act. So the activities for which you can get a right of entry order, therefore, are removal of minerals, construction of tank stations and structures connected with those mining or drilling operations, construction, operation, or removal of a pipeline, construction, operation, removal of a transmission line, or of a telephone line. So those are the things for which you can force your way onto land that's not owned by you if you hold a license or if the activity is license exempt. So that covers right of entry. Let's go to the Oil and Gas Conservation Act. Now we're talking about here, people want to know if you can lock the operator off your land if he hasn't paid, or if you have, so more importantly, if you've terminated the lease. So the quick answer is you can do so for operational reasons, but you can't do so for anything that has to do with maintaining the safety of the well, reclaiming the land, remediating the land, etc. So we're going to come to that. So this is the Oil and Gas Conservation Act, and we're looking for section 101. So that's in this here. So provisions of general application. So we're going to look here, and it's called entry on land. So if we look at that, it says that a person ordered or directed or authorized to provide reasonable care and measures in respect of a well, a facility, a well site, or a facility site, or, this is the important part, to carry out suspension, abandonment, remediation, or reclamation, okay, is entitled to have access to and may enter on the land and any structures concerned for the purposes of providing the reasonable care. So bottom line is you can, if the operator's in default and you have terminated the lease, you can keep them off the land for operational reasons, but you can't keep them off the land for these reasons. That would be suspension of the well, abandonment of the well, which means plugging it, cleaning up the well site, remediating the well site. Don't lock the Orphan Well Association out, in other words. That's what this is saying. So this provision was added in 2020. Before that, it was just under this Liabilities Management Statutes Amendment Act here. It was added in 2020 because of, in my view, because the Orphan Well Association was trespassing, not for well abandonments or plugging, but was trespassing for, or potentially trespassing for land remediation and reclamation, etc., or to go on to shut these wells down if there's no operator available to do so and nobody's looking after these wells. This is this, care and measures to prevent damage, that sort of thing. So that's the provision of the law that grants them access, that you can't deny access. Now, it says a person who enters on the land for those reasons that we've just discussed shall compensate the landowner or the occupant for direct expenses and any damage. So if you can't come to agreement with them for the compensation when they enter, the dispute is to be settled. The compensation is to be determined by the Land and Property Rights Tribunal. Now, I'm not aware of any cases where this has actually ever happened, but it is a relatively new provision, and so I pointed out. So yes, lock them out for operational reasons. Do not lock them out for the other reasons stated in section 101 subsection 1 up here. If you do, and you're going to the Surface Rights Board or the Land and Property Rights Tribunal to collect your payment from the government because the operator's not there anymore, for example, or to collect it from the operator under section 36 of the Surface Rights Act, they may deny your payment, saying you improperly, contrary to law, block the access. So we're not going to pay you anymore. So be very careful. Now, if you've only blocked them because you have properly terminated the lease and you're keeping them off for operational reasons, well, the Surface Rights Board must still pay you. So that's an important distinction. So so don't just lock the operator off, or certainly don't lock the Orphan Well Association off the land. Make sure you comply with section 101 of the Oil and Gas Conservation Act. And now we also have to look at the Pipeline Act, because there's a similar provision in section 28, part 4 here, that's essentially identical. And it says, section 28, we'll go down and find it. It's got the same title, Entry on Land. And if we go there, it says, that same thing, a person authorized to do these same things, they may enter on the land or any structures for the purposes of providing this reasonable care. So, and then it says here that it says that they may enter on the land for discontinuation or abandonment operations of the pipeline. So discontinuation means disconnecting the pipeline from all other pipelines and operations, filling it with a safe liquid so that they could preserve it for future use. Abandonment means they're literally capping it on each end and putting a safe liquid inside of it, and they're just going to leave it. They're not going to maintain cathodic protection, and they're just going to hope it corrodes away in the ground over time. They're never going to remove it. That's what abandonment in place means. So the same thing here. Now, unfortunately, most people aren't getting annual compensation for pipelines. That's a problem. For that reason, pipeline right-of-ways are almost never certified as reclaimed. So the law in Alberta is the operator must reclaim his pipeline right-of-way and give the land use back to you so that you can build on it or do whatever you want. You're not restricted by that pipeline right-of-way agreement. But unfortunately for landowners, there's no time limit. So the operator can say, oh, I'll do it 1,000 years from now. And there's nothing anyone can do about it. That's a whole different topic that needs to be discussed in a whole different video. And landowners need to lobby government for a change in that law because lots of pipeline lands are, they should be returned to the operator. The pipeline is actually abandoned. So there should be some provisions that after abandonment, that triggers a mandatory reclamation within a reasonable period of time. So, indefinite, forever, 1,000 years, 10,000 years, that's unreasonable. So that pretty much wraps up what I want to discuss. But just stop sharing my screen. Make sure that if you lock an operator out, you're doing so according to law. Make sure that it's only for operational reasons. That's the short skinny here. So just to sum things up, yes, you can terminate a lease if the operator's in default. Check the lease for that default clause. If it's in there, which is almost for sure, make sure you give the right written notice. And if they don't clear the default within the time frame you've given them, at least 30 days, then you can terminate the lease. And once you've done that, you can lock the operator out for operational reasons. Make sure you're not locking them out for other reasons. Maybe put a note on the gate if you've used a gate in a tube or something saying, here's my phone number. I'm only locking you out for operational reasons. And if you want to get in for safety reasons, or if you want to get in for reclamation or remediation reasons, cut the chain or give me a call at such and such a number, something like that, perhaps. I don't know. Use your common sense. Thanks for watching. I hope this helps. Anybody that's affiliated with a surface rights organization or those organizations feel more than free to use this video to educate your members. My pleasure. Thanks for watching.